Today on Tux Rules, a music law update about some pending legislation that's before the U.S. Congress right now, and I answer a viewer question from last week's episode. I love those questions and the interactive nature of this, so please keep those questions rolling in. Are you guys ready? Let's go. As a member of the Grammy organization, I had the opportunity to visit with U.S. Representative Pat Meehan of the 7th District of Pennsylvania yesterday. The point of the meeting was to advocate for a statute called the Fair Play, Fair Pay Act. It is a proposed law that's currently with the House of Representatives as House Bill 1836. What this proposed law would do if enacted is to create a more equitable royalty system for songwriters and creators across different platforms. Currently, there's a very wide disparity in the royalty rates that songwriters receive from internet distribution, from streaming services like Pandora and Spotify, and in some cases, there are no royalties being paid from AM, FM, traditional radio stations. The Fair Play, Fair Pay Act intends to remedy that and create a statutory royalty scheme for artists. I'll keep an eye on that law, and I'll update you on a future episode to see how it progressed. Many thanks to the Grammy organization for allowing me to participate in the District Advocate program this year. From last week's episode, I received a question from a viewer who runs a video production house in the region. Here's the question.
Hey Brian, it's Marta from Countess Communications. We have a question about raw video. Since the raw material is what makes the video, do we own it? Does the client own it? And if we own it, how much is it worth?
Thanks for your question, Marta. I really appreciate it. And the question you pose is a good one. And I've heard this actual issue pop up quite frequently. My answer is always this. It's a matter of contract. It's a matter of what the parties want to do going forward with the raw video. As everybody knows, whenever you produce 1 minute of finished video, you end up with 10 or 20 or 30 minutes of raw footage that you end up not using. Now, if you're the production house, it would make sense to want to keep ownership or at least an irrevocable license to use that footage for other projects so you don't have to reinvent the wheel and get the same B-roll every time you start a new creative project. So I think you have to word your contract very carefully. From the production house's standpoint, I think the right to use the footage is just as important as ownership. And if you call that an irrevocable license, you will have the rights to use that going forward for many different projects. The key in this issue here is that we want to make sure the scope of the license is very, very broad. So in other words, I can give you an irrevocable license to use raw footage that you've shot for my project, but you may only be able to use it for certain circumstances. So if I'm the production house, I want an irrevocable license to use the raw footage for any reason at all that I may need in the future. Flexibility is always the key. Of course, ownership of the raw footage is always better if your client will allow you to do that, but every situation is different, and with a little bit of creative thinking, you can come to a solution that helps everybody. I hope you all liked this video. If you did, please give the video a like, subscribe to the YouTube channel, or subscribe to the show on iTunes now. And I hope I will see you next week. If you have any questions about the entertainment industry, the law, nonprofits, startup businesses, just send them to me and I'll feature them on the next episode. Thanks. And remember, the details matter. Make sure those contracts are tight. I'll talk to you soon.